Bing, 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 bing. We're live. It's now, gosh, I've lost count. We're somewhere up into the 8th or 9th presentation today for the Agile Ventures Conference. We're very lucky to have James Bohr, who's got expertise in the security area and is also one of the fantastic trustees of the Agile Ventures charity. He's going to be talking to us about some big changes we've had in Europe recently, reverberating around the world, no less. It's the GDPR. James, thanks so much, and take it away.
Okay, so you've probably heard about GDPR because there was all sorts of panic about it, and I guarantee that's still going on in some very large companies. But it's a lot simpler than most people are reading it as. I'm going to start from the assumption that no one knows much about it, work through some definitions and go from there. If you do know something about it and want to ask a specific question, feel free to jump in, and here we go. If I can work out how to go through slides, that's going to be interesting. Okay, so the first thing is that GDPR covers personal data, and it's got a very specific definition of personal data, which is slightly different to the previous legal definition. And it's that personal data relates to an identified or identifiable individual, which means that your name is not necessarily personal data. Your name might be shared. If it's simply your name written somewhere, that's not personal data. It doesn't really relate to you, and it doesn't necessarily identify you. However, if your birth date and your email address are in separate files, but those can be related, that may identify you. So if you can correlate different sources to identify a person and tell something about that person, that is personal data. There's also a category called sensitive data, such as medical, religion, various protected characteristics. Anything you might actually consider a bit sensitive is sensitive personal data. It's quite a straightforward definition, and that requires a different class of consent if you're basing it on consent, called explicit consent, which we will get to, but only briefly. And the three pieces of legislation to look at here are the DPA, which is the Data Protection Act, updated for 2018, and all they updated in it was that it now implements the GDPR. GDPR is the General Data Protection Regulations, which is a EU directive, and the aim of it, not necessarily the effect, but the aim is to hand more control of a person's data to that person rather than the people holding it. Does also give a clearer and stronger definition of consent than previous legislation, but that's not as big a change as people think. And the other piece, which has slipped under everyone's radar, is the PECR. So a lot of the emails you'll have been receiving about, oh, please consent to our mailing list, will actually have been completely wrong, possibly illegal, and are more appropriate under PECR regulations, which cover specifically marketing. So the GDPR and PECR do sit side by side. They work hand in hand. The PECR is due to be updated soon. We don't know the details yet, but expect some big changes and another round of panicked emails from marketing companies. So, consent. Because there's a legal definition, consent is defined under the GDPR, and it must be, this is meant to be all in pretty animation, but unfortunately I can't work out how to skip pages, must be freely given and well informed. So you must understand what you are consenting to. It must be indicated by a positive action. So that means you cannot have a tick box pre-ticked. And finally, for explicit consent, it must be expressly confirmed in words. So you can't do a tick box to share medical data on someone. It must be typed out, spoken, written, something along those lines where someone has explicitly written it down that they want to share that information. And that's just consent. The PECR, they are due to be replaced, as I said earlier. They are separate to and are not superseded by GDPR, and they will cover all electronic marketing. So that's everything from calls, texts, emails, faxes, if anyone still has a fax machine, web advertising, tracking technologies. Also has a little bit in there about telecom security, which I'm mostly going to skip over on this as it's only relevant if you own a telecoms network, and user privacy on communications network, which is basically saying they're not allowed to spy on you. And they apply if you are doing electronic marketing of any sort, if you are using any cookies or web tracking technology. So not necessarily a cookie, it could be anything, including tracking someone's IP address if that stays consistent, or if you compile a public contact directory. So if you've got a list of people's addresses, that comes under PECR. And they restrict certain activities. So they restrict the unsolicited marketing that comes through your letterbox every day. They also restrict those robocalls that you get. Those are illegal under the PECR in most cases. They specify that you must be informed of any cookies or other tracking technology, what they're for, and you must consent to the usage of them. Now, one thing which is going to change is that under the new regulation, it's expected you cannot require consent in order to use a service. So you can't force people to consent to the use of cookies to visit your website unless they're essential to the functionality of your website. And then there's communications platforms. There's a lot of stuff on telecoms in there, and most of it's only relevant if you own a telecoms company or work for one. Now, the big thing is that the GDPR is often viewed as being about consent. And the question that's always asked when I start debating it is that isn't it just about consent? There's a very simple, easy answer to this. And the subtitle earlier may have given you a clue. Consent is not the point of the GDPR. It is hand control of data back to the users or back to the subject of that data, but it's not as simple as saying they must consent to everything. So, under the GDPR, you now have a right, and anyone, if you're gathering data on them, has the right to be informed what data you're gathering. And if you're gathering data, you have a duty to act as, to put it simply, a custodian rather than an owner. So you can no longer make the decisions about what that data is used for. You must inform the data subject. You must make sure that they not necessarily agree to it, but are at least aware of it and have had an opportunity to object. I say object for a specific reason. So there are 3 specific rights, among others, but these are the main ones that get people het up a bit under GDPR. Erasure is not just a old and rather bad sci-fi film. It's also giving you the right under certain bases for processing data to demand that your data is erased. And that's all instances of your data. So that includes historical backups, but that only applies under certain bases, and we will get to those. There's portability, and portability means that as a data subject, you have the right to take your data and use it on a different service, an equivalent service. So yes, this does apply to something like Facebook, where you now have the right to demand that they provide you with all of the data they've gathered on you so that you can take it to some massive worldwide monopolistic social network and use it there instead. I'm sure someone will invent one soon. And you also have the right to objection. Now, objection is not saying, oh, you're not allowed to use my data. It is saying, I don't feel that is an appropriate use of the data I've given you. They must consider it, address it, and respond. But it doesn't guarantee that they will not use that data. So if you get a speeding ticket, you can object to the under the basis you don't want them processing data for that purpose, and they will have to write a reply to you. I wouldn't recommend doing that because it's not likely to end well, but you do now have that right. The lawful bases, and this is where it's not all about consent. While consent is at the top here, it is considered the weakest of the bases. The others are contract, where you have a contract with a person or organization, which means that you must store their data. You can't really pay someone or receive payment from someone without some of their data stored. Under that, you cannot ask for your data to be erased. You cannot ask for your data to be exported from whatever system it's stored in. You are allowed to object. Legal obligation. Under legal obligation, that goes back to the speeding fine, you are allowed to ask for it to be erased. If legally it has to still be stored, then the GDPR does not apply. But if it does not have to be stored, then yes, it can be erased. Same applies to portability, although I've yet to see a test case with that, and it will be interesting when one comes out. And yes, you can still object to your data being stored under a legal obligation. I suspect most of this will come down to parking companies, private parking companies in particular. Vital interests and public tasks are interesting ones. So vital interests are essentially public tasks if you're not a public body. They are things which are essential to the interests either of a person or an organization, and we are talking life and death. So medical data, for example, can be processed under vital interest. Public task is your council tax, anything that's being dealt with by a public body, and it must be a public authority of some kind. An organization is not a public body unless it is governmental. And finally, there's the most flexible one, which is legitimate interests. And that means that data can be gathered, stored, and processed under the legitimate interests of either the person gathering it or the data subject. That's the one that's going to generate the most court cases because the test there is rather soft. But the aim of it is essentially to say that if you have a legitimate interest in using this data, or a person has a legitimate interest in you processing their data in this way, then yes, you can do it. Now, the notable thing is, the only one of these that actually requires consent is the consent basis. So 5 of the 6 bases do not require consent at all. They do require you to be informed, but they do not require consent. Consent is fairly obvious. You have given clear and explicit consent to process your data for a purpose, or you have given that consent. Contract, it's necessary for a contract or agreement, or in order to establish a contract or agreement. So you can process personal data under contract if you are setting up a supplier contract with someone or working on an agreement to provide them with a service. Legal obligation. Now, this one's slightly interesting because if the law requires that data is gathered, processed, or stored, GDPR does not apply. It does not trump any existing legislation. So certain companies have to keep financial records of all paychecks for 7 years. That is definitely personal data. It means that a person is identifiable and the data very definitely relates to them. So under GDPR, you might expect to be able to ask that your employer deletes those records. There are other legal obligations already in place from HMRC and other bodies saying that that must be stored, and they trump GDPR. Vital interest. So the key part here is that it is a vital interest, not necessarily to the data subject. If a body or if an organization feels that someone is a danger to another person, their data can be processed under vital interests to protect the other person. Public interest is obviously the clear and lawful public interest, or for official functions. It's government. If they want to store your data, they're going to one way or another, so we'll have a law that provides for it. And finally, the flexible one, the legitimate interests. Now, interestingly, and I still find it slightly funny, no public body can process or store personal data under legitimate interests. So you could argue that it's always illegitimate, but that goes down an anarchy route. In fact, all it means is it should be a public task in their cases. For anyone else or for any other organization, it can be dealt with under legitimate interests. So really, it all boils down in quite a simple way. And the amount of misinformation out there is quite scary. You can think of it very, very simply. GDPR requires that if you're working with someone's personal data, whether that's gathering, processing, or storing, you think about why you're doing it and you record that reason why, along with any other relevant information. So if it's under consent, you say, yes, they consented to this. If it's under vital interest, you say, yes, it's in pursuit of this vital interest. You keep the data subjects informed, so you tell people why you are storing and processing data, and in most cases, also give them a clear method to object to it. So when you're informing someone, we're storing your data in order to give you routing information for how to get from London to Edinburgh, and we will track you along that route so we can give you traffic updates. You have to also include in that an option for them to say, I don't really want that, I want to complain about it. You can then go back to them and say, well, it's kind of vital, can't do it otherwise, but they have to be informed and there has to be a way to check. And ensuring that anyone processing data on the behalf of an organization fulfills these same duties. So a data controller is the person or the organization that makes decisions about how that data is processed and what it is processed for. A data processor may be someone instructed to process that data. So it's not necessarily the same person. There are similar duties, but the data controller is someone who is accountable to the data subject. And of course, you must practice reasonable security. And it is actually written in the legislation as reasonable security. It's going to be great fun to hash out in court, but essentially means you do best appropriate efforts. If you are dealing with a couple of hundred people and it's fairly pointless personal data and it's in their definite interest, then reasonable security might be quite minor. If, on the other hand, you are dealing with, say, a sixth of the world's population, then reasonable security, the bar is going to be set much, much higher. And fines under GDPR are high and are designed to be high and scary. But the important bit is they are selected appropriately. So if you're practicing reasonable security for your capabilities, you are actually quite unlikely to get a fine if you've suffered a data breach. If you are not practicing reasonable security, you will be hit with the maximum possible fine. And just to be clear on what those are, one of them is 10 million euros. The next level up is 20 million. Alternatively, if it's higher, it can be 2% or 4% of total turnover. So one important note about GDPR is it applies in the EU to all EU citizens or all residents within the EU. It also applies to their data wherever in the world it is. So yes, it does apply if someone's data is being stored outside the EU. How that will actually work in court, I don't know, but there are a couple already, so we'll find out in a couple of years. And finally, if you are doing a reasonable amount of magic word again, you must appoint someone responsible for keeping an eye on you, making sure you're on the right path. This essentially is a trustee in a fashion. It's a trustee for data. They're called the data protection officer. They are largely expected to be, I hope I'm not breaking up for anyone else because I would have trouble running through this all again. They are largely expected to be independent and they are expected to hold the data controller to account. So, if anyone missed any points because I was breaking up, please let me know and I'll go back to them. Otherwise, if there are any questions, I'm happy to go through them now.
Excellent. Thank you. Thank you, James. Wonderful. Yes, the audio broke up a little bit. I was able to follow it myself. Any questions from anyone at all? I had some clarification questions on I was wondering if you could go back to the all your lawful bases slides, where you had one slide where you had the 6 things down the left, and then you had the 3. Well, there you go, that one there. And I was just, so this slide here. So we've got these 6 different bases, and these were the bases that you as an organization might have for doing something. So for example, you might have consent by someone's filled in a form, or you might have a contract because they've signed up for a service. And then, so for each of these 3 different rights, these are what the individual, not the organization, what the individual would have. So this is sort of saying that the individual would not have the right of erasure, given that they've given their consent.
Now, consent's a bit of an odd one there, and that's why objection is put down as sort of. You can't object about the fact you've given consent. What you can do is withdraw consent. And at that point, they've got no lawful basis for storing or processing your data. So yes, they must erase it.
Oh, okay. So I guess it's saying, right. So that if you have consent, then you're not. It's not the case that you would need to erase or make it portable, unless they withdrew consent. And then if you're given a contract and you're doing some work for them, or what have you, so then they wouldn't have the erasure or portability, but of course they could object. So I was just sort of the bases there list. That's all the basis that the organization has for working with the individual's data, and then the yeses and nos are whether the individual has that particular right as regards their data is stored by the organization.
Yes, that's right. And part of this is that you can only process data under one basis. You can process different parts of someone's data under different bases, but only one basis applies to any set of data. So if you're treating someone's financial records, you might be doing that under contract.
Right.
And the records of past payments, you might be dealing with under legal obligations.
Right. And you're making a distinction there between their financial information and the record of the past payment would be 2 different kinds of data, each of which dealt separately with on a different basis.
Yes, because the past payments you're not holding under contract anymore. The payments have been made, or they have made the payments, but your legal obligation to HMRC might be to still hold those records.
Right, and so there, in the context of the legal obligations, so you've got the legal obligation to hold on to the records for 7 years, but the individual would still have the right to erasure there, so they could override that legal obligation there.
They could request erasure, but in the case of the 7 years one isn't an ideal one for that, because the 7 years is a legal obligation instilled by law. It trumps the GDPR. There's certain edge cases where you might hold on to data to help you fulfill a legal obligation, but it's not essential to that purpose.
Right. But so in principle, the implication there is that kind of legal obligation is in some ways the weakest, in that that's the one where effectively the individual has the most rights in terms of erasure, portability, and objection.
Yes. If we go back to the parking contractor, that would be asking them to delete any record of your number plate.
Right.
They might argue they have a legal obligation to hold it, and that's what they're processing it under to go to court. However, there's no law that states that they must do that, and therefore GDPR applies, not an existing law.
Right. Interesting. Yes, well, it's particularly interesting when you say that the PECR is going to be changed again soon as well.
Well, it doesn't match up with GDPR anymore, so they need to update it to deal with that. But for example, the telephone preference service was brought in by PECR.
And that's, when you say telephone preference, that's the no call list, or that's the being able to switch between telephone providers?
Yeah, that's the no call list.
Right. Which we go on, which we're on, but we still get the junk calls. But yes, come on.
Yes, those are illegal. Very unfortunately, they're also very hard to trace.
Yes.
Switching between providers is also under the PCR, oddly enough.
Right. Yes. Yes. Fascinating. I mean, we're trying to do quite a few. Like, so we've updated the consent in Agile Ventures, the main website one, on the basis of GDPR, and we're busy reviewing privacy policies and so on. Most of our legal expenses this year are for that, particularly for the NHS Wiki project. It seems like it's but yeah, with the new PECR, it seems like it's going to be an ongoing thing, really, to try and stay legal.
So PECR will apply only to electronic marketing and electronic communications. So if you've got an electronic comms platform that you're setting up, PECR will apply. Otherwise, it will just be marketing. That's the main part of it that will be relevant for most people.
Right. I guess in my mind is that, but it's or PECR also concerns the cookies, and so the thing that you were mentioning before about what was it that you can't make it, or was it you think it was going towards you can't make it a requirement to use the thing for? But so, for example, pretty much everybody has Google Analytics cookies on their site. So there's the implication that in maybe now, but or even in the future, that you would need to allow someone to carry on using your site, but to be able to turn off the individual cookies and provide that functionality through the kind of web interface.
That would be something that Google would have to take care of, because it's their tracking technology. So if you were using your own tracking technology, then yes.
But right, okay. So it should be sufficient as long as you're informing people that you've got Google Analytics cookies on your site, then that should be sufficient. You don't have to provide them with a specific tool to turn off that cookie and continue working on your on the site.
That's right. You can't make usage of your site. This currently just under GDPR. You cannot make usage of a service dependent on the provision of personal data unless that's inherently essential to providing that service. So you couldn't do a social network without personal data being involved, for example. But if you were doing an online shop, you don't necessarily need to provide as much personal data as many of them ask for.
No, right, and I guess Google Analytics by itself is not usually it's not accruing enough data to be personal data, is it? Like it's kind of getting a few, like you're saying, like maybe getting IP address or other bits and pieces, but it's not storing people's email and date of birth and so on.
Google Analytics goes into almost philosophical grounds there. So yes, the data gathered by Google Analytics is personal data gathered across multiple sites. So the data gathered by one individual site is unlikely to be personal data.
Right.
The data held by Google across 500 sites is likely to be personal data because it's identifiable. You can correlate it across different sites, work out who someone is, and it very definitely relates to them.
Right. But so that's interesting. Like my probably limited understanding of cookies is that if I guess the cookies, they only get returned to the existing. But I guess I wasn't aware whether the Google could, with their analytics. So say that we've got Google Analytics on website one, and we've got them on local support, two of our projects, and that's going into. We see that data completely separately in Google Analytics. But so you're saying in principle, could Google be like, if I visit the website one site with my browser and it then obviously contacts the Google server, then and I subsequently go to the local support site, can it then like it can know that the same individual visited those two sites? Is it doing that? It's not obvious to me that it necessarily would, but you're saying that you think it can, or indeed maybe they do that. I mean, it's a big part of what they're doing with Google Analytics.
It is a big part of what they're doing, and funnily enough, last year, as part of their preparation for GDPR, Google put something in place. So if you go to, I'm going to check it still works, I'd imagine it does. If you go to myactivity.google.com, you will see a rather disturbing amount stored, which can go into rather a lot of information, including geographical data and so on, because they've got an identity that they tie it to, they aggregate it across those, and it is tied to an individual. However, because of GDPR, you can request that it is deleted, and it is actually portable.
Right. And so this, I mean, it's showing my previous searches there, but then, right, interesting. Is this also showing activity based upon, yeah, cool. Anyway, sorry, I've been kind of dominating. Did anybody else have any questions about GDPR or PCR or any of these other exciting acronyms for James, or any anecdotes about, you know, people going crazy about GDPR in their own organizations? I guess not. I guess people have been stunned into silence by the accuracy and clarity of your presentation, James. GDPR, it certainly has been extremely confusing for me. Yes, it was very very helpful.
It is really, GDPR is quite simple in that the aim of it is to hand over control of data back to the data subjects and to make the people processing and holding it custodians rather than owners. It may not have exactly that effect. It's got some fluffy edges which are going to be worked out in court over the next few years, but ultimately that is what it is aiming to do. So if you're thinking about any data you store and why you're storing it, you're largely covered.
Good show. All right. Yes. Well, let's wrap up there. Thanks so much, James, for being available with that presentation. Really appreciate that.
No problem.